Hey Paul, how's it going?
Good. How are you doing?
I'm pretty good, pretty good. So I hear you had some questions for me. Well, just to start off, my name is Alexander Cross. I run a criminal defense law practice here in the San Francisco Bay Area, and I have Paul here with me, and he may have some questions regarding what we do. And I'm sure people out there in podcast land are interested in some of this, concerning that this is something that affects so many people. As a matter of fact, 1 out of every 3 people that lives here in the United States has been or will be arrested at some point. But an even more alarming statistic is that 1 out of every 20 people that has actually been convicted and sentenced to jail and prison is factually innocent. So I understand you have some questions for me, Paul. What do you want to talk about today?
Well, I mostly want to talk about DUI for this session, if that's all right.
Yeah, absolutely. Driving under the influence is a very, very common offense.
Yeah, 1 out of 3. Everybody likes to have a couple of beers at the bar and
absolutely, stuff. Absolutely.
For me, I'm 6 foot 2 feet inches, weigh 200 pounds. What is a general rule or something for blood alcohol to make sure I'm under 0.08? Is it 2 beers for an hour, 1 for an hour? What would you give your general rule of thumb?
Okay, this is what it is. Generally, the statistic we tend to use, or the numbers we tend to use, is this. For a man that weighs 165 pounds, generally speaking, we're talking about 2 to 3 beers. That's about it, to be at a 0.08 or more. Now, if you're somebody who weighs about 200 pounds, I would be guessing about 3 to 4 beers. That's what I would give you. Now, it takes 3 hours for all of the alcohol to metabolize in your system, with 1.5 hours being the top point where you're going to be at the highest point regarding your BAC.
All right, so 1.5 hours. So if I'm there for 3 hours, then because my perception was it was 1 hour, you could take one off and drink another one. You're telling me it's a little longer than that?
It's longer. Like, yeah, generally speaking. In order for, let's say you want all of it to dissipate from your system, like 100%, that would be 3 hours.
Gotcha.
It takes 3 hours for alcohol to pass through your system.
Gotcha. Well, mostly for someone at a party or something, it's like,
right.
Well, I'm going to be at the party for 3 hours. I can drive back with a 0.08. Would I then, without buying a whole monitor with 5 beers, would that be a safe bet?
No, I would stick, to be honest with you, if you really wanted to be safe, 100% safe, I'd stick between 3 and 4 beers. For your and sign.
Even for 3 hours, because it takes that long.
Absolutely. I wouldn't take personally that, but here's the thing. Here's the thing. Just because you're not at a 0.8 or above, it doesn't mean you can be charged with an offense. Theoretically, if you look at section 23103, you can be charged with reckless driving, or rather wet reckless. And you can be charged with that if an officer feels that you're driving somewhat dangerously and you have alcohol in your system, and you don't have to be at a 0.08 or more to be charged with reckless. And that is still a misdemeanor, I might
add. Wow. All right. Say if that was the case, and I truly think I'm below a 0.08.
Right.
Can I refuse the breathalyzer, or should I refuse the breathalyzer?
Okay, here's the thing. We have to define what breathalyzer is, first of all. See, here's the thing. Most people, when they're given a little box to blow in out in the field when they're initially arrested, they assume that that's what the breathalyzer is. That is not the breathalyzer. When the police make you blow into a device out in the field, that is the preliminary alcohol screening device, pass test. You actually do have the right to refuse blowing into the pass device, which is the preliminary alcohol screening device, out in the field before actually being arrested. However, this is a big key. However, if you are currently on probation for a previous DUI offense, then no, you do not have the right to refuse a pass device. However, after being arrested, being taken to the station or to the jail, at that point, you do not have the right to refuse the actual breathalyzer. Now, the breathalyzer device that we use here is called the alcohol test device.
Sorry to stop you. What do you mean by here?
Okay, here in the San Francisco Bay Area.
Okay. I just want to clarify that.
Right.
That would just be in the Bay Area.
Yeah, generally that's the device that's actually used. Now they do have other versions of that device throughout the entire state of California.
Okay.
I'm just talking about the alcohol test device that is used here in the San Francisco Bay Area. That one you do not have the right to refuse, and you do not have the right to refuse any chemical test after actually being arrested. The reason is because when you are driving on the roads here in California, you have given implied consent to the police. You've already consented in advance.
Okay. And does that include blood as well?
Absolutely. You do not have the right to refuse a blood test. Now, here's the deal, though. Generally speaking, the police have to give you the option. You have to give the option to blow into the alcohol device, which is known as the breathalyzer, or blood. You have to do one or the other, but you can't flat out refuse. Now, if for some reason their machine is not working, the breathalyzer machine, the alcohol test device is not working, and there is no choice but to take a blood test, if you refuse a blood test before taking your blood by force, they have to get a warrant. Now, they don't have to. They can just flat out say that you refuse a blood test. And if you refuse a blood test, that just goes down as a technical DUI, and they don't even need the evidence, quite frankly.
Really?
Yes, really.
So even if their machine isn't working, even if I have a lawyer on retainer, I should still take a blood test.
Oh, you still have to take a blood test.
I mean,
Oh, absolutely.
So I can't.
You don't have the right to an attorney.
I see.
That's the thing. You do not have the right to an attorney before a blood test. And it's a really sad thing, by the way, is that brings up another point, which is, ignorance of the law is not a defense. It isn't. So a lot of people feel, oh, and I've actually had clients who've told the police, oh, no, I'm not going to submit to a blood test without an attorney, because they assume that they always have the right to an attorney, and that's not the case. That's not always the case. Prime example. Hey, you don't have the right to an attorney before submitting to a chemical test. You don't.
I see. And that just goes, that would be under all drugs, marijuana, crack, all.
This is specifically for driving
while
under the influence
Gotcha, okay.
of alcohol or a controlled substance, DUI.
Mm-hmm. Gotcha. And then, I forget what my other question. Oh, would it then actually be smarter if you do have a little bit of a higher blood alcohol than to say, hey, I would just prefer to go to the police station on one test, so have a little time go by?
It would be better if you refused the pass device out in the field and then just took the breathalyzer at the station or something to the blood test actually at the station. So a lot of times, sometimes the police won't even want to bother with you if they feel that, okay, you're not agreeing to do a pass test. It's going to take me an hour to get them to the station. By the time I get them there, it might dissipate. There might be some other issues. They might not even want to bother you, quite frankly, and it happens.
I can imagine it. And so that probably would be your best advice then.
In that instance, yes.
Yeah, I got you. All right. I have another question here, and I actually didn't realize.
What's your question?
If you notice a DUI checkpoint ahead, and you might have been drinking a little, is it the smartest if you can to turn around?
Well, absolutely. It's perfectly legal.
That is.
It's absolutely perfectly legal. See, a DUI checkpoint, it needs to be published in advance. You have to have a clear way of exit because it's technically supposed to be voluntary. Now, some law enforcement departments will try to bend the rules and avoid the publication, but when it comes to DUI checkpoints, you have to have a clear path away from the checkpoint.
Oh, really?
After being made aware. And by publication, I mean it could be newspaper, it could be a big sign that's 5 miles away that says DUI checkpoint, but you have to have the option to be able to get out of it. Absolutely.
I see. All right. Because that's always been a big thing. But
oh, absolutely, absolutely. And it's a common thing. Could
you, if you say, see in front of you freaking out, just stop on the side of the road and park?
Oh, give me an example.
I'm driving and I'm going to Vegas.
Yes.
And I see a DUI checkpoint 30 miles before I go in. I was at Prim State Line and I had 4 or 5 beers.
All right.
And I don't know if I'm going to be over. Actually, that's a zero policy right there. And say we're in California.
Yeah, I'm assuming California.
There's really no way to go around anywhere if you're going in Nevada.
All right.
To Las Vegas. Can you just pull over to the side and get out of your car and start playing with bushes and stuff?
Well, the problem is this. Let's say you do pull over, and you're pulling over where is a good question. Because see, the thing is, you don't want to do something that could rouse suspicion. For instance, you can't just pull over on the side of the freeway. You can't do that. A cop would have the right to investigate. He would have probable cause. He'd go, well, wait a minute, if you have alcohol in your system, well, where's the bottle of beer, or where's the booze at? Oh, so you had already been drinking it beforehand. Let's see, blowing this thing, or I'm going to take you to the station right now and see if you're at 0.08. I mean, or above. So the thing is, I mean, yeah, you could pull over if you're talking about specifically just doing anything possible to avoid the police. Well, yeah, I mean, that would be common sense. But for instance, let me give you an example. Let's say you pull over, and you're not driving the vehicle per se, but the key is still in the ignition. Well, that technically counts as driving. So I mean, you don't want to do anything that would potentially arouse suspicion of the police. Because remember, the police merely need to have probable cause to either pull you over or to basically to begin an investigation.
Gotcha. And that's usually what they're looking for.
Exactly. They're looking for any legal excuse to pull you over or to commence an investigation.
Gotcha. All right. Kind of clears that up. Another question I had is, what are the laws now of being pulled over if you have no driver's license? Kind of not even if you're drunk or if you are, or if you're not. You have no past felonies, but you get pulled over
and you have no driver's license.
You have no driver's license.
Well,
what's going to happen under most scenarios?
Well, legally speaking, under Vehicle Code Section 12500, it is actually a misdemeanor to drive without a license here in California, provided that you lived in California for over 3 months. It is a misdemeanor to drive in California without a California driver's license if you've lived here for over 3 months. And if a police officer wants to, he can arrest you. Although most of the time they will just cite you, but he can arrest you. And if you look up the code, and I know this is going to sound ridiculous, it does say 6 months in the county jail.
Jeez.
Yeah, 6 months.
That's a scare tactic, though.
No, that's literally what it says in the code.
And how did that get even passed?
I couldn't tell you, legislature. It's a misdemeanor. It's a misdemeanor.
For 6 months.
Yeah, 6 months. You can get up to 6 months.
That means even if I had a Nevada driver's license and I've been living here in California, I could get 6 months.
Yeah, provided you've been living here for more than 3 months, yeah, you have to get a California driver's license.
That's crazy. But recently here in the state of California, and I think we're leading, we're allowing people without social security numbers to get driver's license.
Yeah, that's correct. That's correct. Under AB, it's a U.S. code, AB 60, yes, you can get a California driver's license without a social security number, provided that you can establish proof that you live in California, usually with some kind of utility bill or something like that, and you have to show proof of, what you call a birth certificate and that sort of thing.
A birth certificate, and so that could be from Mexico, that could be from Europe, that could be from anywhere.
Absolutely.
And then just some sort of utility bill, or maybe your landlord, tenant, or
exactly,
like that.
Exactly.
That's all you need. Now, is California the first state to allow that?
No. There are other states that have allowed people without social security numbers to get licenses. As a matter of fact, you have Washington, Oregon, they've been doing that for years. As a matter of fact, a lot of people that are undocumented come here with Oregon driver's licenses and with Washington licenses, thinking that it's okay, but they don't understand that California doesn't have reciprocity with other states. California does not recognize the licenses of other states.
All right. For us normal people, what is reciprocity?
Reciprocity, it means when one entity recognizes the other as its own and vice versa.
Okay.
So California does not recognize the licenses of Washington. Quite frankly, they don't recognize the licenses of other states if you've lived here for more than 3 months.
And living here means actually being in the soil of California.
Yes, physically being in the soil of California. By the way, and I know we were talking about DUIs previously, but it becomes a real problem because a lot of times, check this, the DUI schools in California are not recognized. DUI schools from other states are not recognized in California. Let me give you an example. Let's say you are from Georgia. You are coming here to visit relatives or whatever from Georgia. You live in Georgia. You don't live in California. You live 3,000 miles away. You go to a restaurant. You drink 5 beers. You get a DUI. You're planning on going back to Georgia, right? You get this DUI here in California. There's a problem. You have to do the DUI school here in California. And heaven forbid, you have a DUI of a .20 or more. The reason is that's 9 months of DUI school when it's above .20. Now, the problem is that You can't go back to Georgia, where you live, and do the DUI school there and satisfy the California courts. Oh, no.
There's no online.
Because there's no. There's no online. There's no reciprocity. So you need to stay in California and do your DUI school here. Major dilemma.
Yeah. And there's no way of getting around it.
Nope. I've tried.
You tried for your client.
Oh, yeah, we've tried. Oh, yeah. They have to literally stay here. Matter of fact, I had a client who lived in Nevada. Thank God he lived on the bottom end of Nevada. And he had to drive to California every week to do DUI school.
Jeez.
Yeah, couldn't do it in Nevada. And no, it cannot be done online. DUI school is not like traffic school. It's not online.
And then even traffic school, it's county by county.
Exactly. Oh, yeah. No. I don't even want to start with the fact that every county in California is different. You'd figure they'd have universal procedures.
Yeah.
They don't.
No, not even in the counties.
No, they don't. No.
I'm going to follow into that with, I know this whole, I've been traveling a lot, red light cameras are used almost everywhere.
Yes, they are.
I know in Orange County, at least, they were installed, and then they were taken out.
Yes.
Because they show that people stop too cautiously and it provides sort of rear-end accidents.
Right. Yes.
Is that statewide now, California, no red light cameras?
No,
Or is that
no.
county by
This is
county?
kind of a county.
Oh, really?
Matter of fact,
In fact,
it's
it's
city by city. City by city. It's not even county by county. That's city by city.
Oh, wow.
Yeah. Sometimes, let's face it, it's a big revenue source.
Yeah. But I thought, have long-term studies not proven there's more accidents with the camera than without?
Eh.
Or that's just up to debate?
I'll be honest with you, it's economics.
Yeah.
That's it. That's the end of the story. I mean, it's economics.
So why are they paying, I know for a fact in Costa Mesa, to take them out?
Well, a lot of people have complained about it. Obviously, you know, need a right to legislature, you need to complain to protest, but generally speaking, the cities will want to keep those there because it makes some money.
I know.
It's the bottom line. It's just a sort of regressive tax, as you would call it.
It's almost as bad as the city of LA. I have a brand new car, has no license plate.
Oh,
I get a parking ticket,
Yep.
no license plate to go.
But it's a new car.
Yeah, I don't get my license plate in another 30 days.
Yeah.
No, they'll just give you the ticket. It's just the same thing.
Yeah,
Revenue
exactly.
source.
Yeah, that's right.
Yeah, I hate
Yeah.
that. All right. One other thing here, going back to DUI.
Right.
If I can't drive, and really here in California, only in the Bay Area is there a metro, not really in SoCal so much.
Right.
What do I do then if they suspend my license?
Well, if you don't, well, here's the deal. If it's the first time you've gotten a DUI, if it's your first offense, your suspension, provided you didn't do anything too horrific, your suspension is generally only for 6 months. However, after your first 30 days of suspension, you can go to the DMV and get a restricted license to be able to drive from home to work and for your necessities, provided that you enroll into a DUI program and you get the SR22 proof of insurance, and you pay the DMV, I think, $125. So even though it's a 6-month suspension, it's really only a 1-month hard suspension.
Gotcha.
For your first offense.
For your first offense. And a second offense?
That's a little worse. There, your suspension is for 2 years. However, after your first year, you can get a restricted license. But what stinks is that for 1 whole year, you legally cannot drive. How much is your second offense? Within 10 years.
Within 10 years.
Within 10 years.
Now, back in this DUI, can DUIs at all affect your chances of employment?
Absolutely, and I'll tell you on two levels. Number one, certain employers, well, first of all employers will look at your criminal background. Because you have to understand, a DUI is a criminal offense. It's not a traffic offense. It's a criminal offense. You are technically legally a criminal if you get a DUI, which means if you are applying for a job, they have the right to ask you if you have been convicted of any crimes. Well, the answer is yes. Legally, DUI is classified as crime.
Now, when they say convicted, what if it was expunged?
Okay, here's the deal. Once it has been expunged, that means your probation period is over, you didn't have any subsequent arrests, you paid all your fines, you did all your school, and the judge forgave it. Yes, a private employer does not have the right to use an expunged conviction against you. However, there's an additional problem. There are some employers that require you to drive. If you're going to be a delivery person, or if you're going to be a trucker, that's different because they will go off of your DMV record. And your DMV record, a DUI will stay for 7 years. So you can still get messed up for 7 years.
If you want to become an Uber driver or something.
Yeah, exactly. So it depends on the type of employment as well. But for a conventional employer, a conventional private employer wanting to get a job at Target, Walmart, whatever, yeah, once it's been expunged, it cannot be used against you. But there's an additional caveat. Remember, I said specifically a private employer. The government,
I've heard of
the
this,
government has the right to use any criminal offense against you, even if it has been expunged. So let's say you want to get a job for the county.
Well, this actually happened to my ex-girlfriend.
Exactly. Or what if you want to get a job, it's even worse, at a bank that's private, but because it has public certification and public licenses, it counts somewhat as semi-governmental. So banks can deny you a job. Hospitals can deny you a job. Care facilities, school can still deny you a job, even if it has been expunged.
Is that just going to be something with federal funding, or is that state funding as well, county funding, city
It's generally
funding?
government.
Just
Government. City, state, federal.
Oh, wow. Okay. So it really can screw you up.
Oh, yeah.
A multitude.
Oh, absolutely. Absolutely. Believe me, you want to do everything possible to avoid a conviction for a DUI.
Yes, I understand. And what would be the best ways then of doing that?
Well, there's a lot of ways. I mean, first of all, you need to establish, or rather, the prosecution has to establish probable cause. When a police officer stops you, he has to have a valid reason for pulling you over, either because you're violating the vehicle code, penal code, health and safety code, business professions code, or you're driving suspiciously. They have to have a valid reason for pulling you over. If a probable cause cannot be established, then anything that the officer discovers, including you being completely hammered, would be considered fruit of the poisonous tree, and you wouldn't be able to get your hand, the DA wouldn't legally be able to use that evidence against you in case it gets dismissed. That's number one. The other thing too is after the arrest, once they take you to the station, and you have those two options of either going into the breathalyzer or alcohol or test device or giving blood. There are a couple of factors to consider. Number one, regarding the alcohol test device, that device has to be calibrated once every 10 days or within 150 uses. If that does not happen, that could call into question the validity of your breath sample. That's one issue. The other one is regarding the blood. When the blood is taken from you, it can't just be some cop taking your blood. I mean, it has to be a licensed phlebotomist taking your blood. It's like a special nurse that literally just, that's all they do, is take your blood. Now, when they clean your arm, they have to use a special solution to clean your arm prior to jamming the needle into your arm. They can't use alcohol. They can't use an alcohol swab. Because if they use an alcohol swab, what? It's going to be at the edge of the needle. So no, they have to use a special solution to wipe it. They jam the needle in your arm, extract the two vials, because they need one for the defense and one for the prosecution, but then you need to know the chain of custody. Where has the blood been since it got yanked out of your arm? All those things are very necessary. Because all those things can't be established by the prosecution. Well, then it could damage the validity of the evidence and it could get thrown out.
Okay. And how often does that actually happen?
Depending. For instance, we're talking about the CHP, California Highway Patrol, almost never. Because they have systems put in place and they almost never screw that up. Now, if you talk about local police, the sheriff's office, park rangers, and they can mess that up. Sure, because they do a lot of other things aside from DUI. CHP, that's pretty much what they do.
And speeding tickets.
Well, yeah, well, it goes hand in hand. That's how it goes. Speeding is quite often probable cause for pulling you over and then eventually discovering that you are DUI.
Is switching lanes quickly?
Yeah. Yeah.
And it's basically anything they can.
Basically anything.
And so if they see a car in front of them, they can kind of make up.
Yeah, if it's dangerous, if they feel it was too dangerous, speeding, coasting, you have a rosary hanging, I mean, anything impeding your vision, I mean, they could come up with anything. You have a microscopic crack on your windshield, one of your, taillights isn't working, whatever.
Here in California, you should not be hanging a rosary from your, what did you call it, rear end?
Absolutely, you shouldn't, because it's impeding your vision. Now,
no GPSs,
no
speed.
You shouldn't do it.
Detectors,
a cop, remember, as long as a cop has a legal reason to pull you over, he can. Even if his real reason for pulling you over is illegal. Let's say You have a cop, and he says, you know what? I don't like that guy. I want to pull him over. Well, he can't just pull you over. But he can say this. I don't like that guy. Let me find a reason for him. Oh, wait a minute. He's got a rosary hanging. Oh, he's got a microscopic scratch on his windshield. Pull him over. And that's perfectly legal. Remember, the actual reason for pulling you over is irrelevant as long as the police officer can find a legal reason. And yes, that is a highly controversial standard.
And is that just state of California or is that nationwide?
Nationwide.
Wow.
Nationwide is by your side. No, I'm serious.
Yeah,
it's nationwide.
Wow. And that comes me to another question. What is the proper procedures when you do get pulled over? Is it always to put your hands on the wheel, or?
No, basically, it's better to keep your hands at sight, obviously. You don't want to get shot.
Yes.
But, I mean, you have to be cordial with the police. They ask you for your license and registration. Guess what? You give them your license and registration. They ask you to get out of the car. Well, you get out of the car. I mean, that's basically it. You have to, do what you're told.
You have to, even if you are innocent, you do what you're told no matter what.
Okay, here's the deal. Let's say you're innocent. Okay, fine, you're innocent. But you still cannot obstruct the police officer doing his job. For instance, let's say a police officer assumes you committed a crime. He has probable cause, or he believes he has probable cause. He decides to arrest you. You can't fight the cop and say, I'm innocent, and try to, get away from him. No, because even if you're subsequently found to be innocent of the underlying offense, you will still be charged with a violation of Penal Code Section 148, which is obstruction of justice. That alone is also a misdemeanor. So remember, just because you're innocent doesn't mean you can physically fight a cop. You have to allow the cop to do his job.
Gotcha. Leading to another thing, if you are arrested innocently and say you're in jail for 24 hours, can you, after the case is over, then go back and sue the state or the arresting officer for lost wages, for a missed contract, or anything like that?
Only
or do
if,
they have a
only if it wasn't reasonable. Remember, fact is irrelevant.
Only if it wasn't a reasonable cause for them.
Right, if there was no probable cause and they had no reason, it was clear that he was just messing with you, then yeah. But if the cop reasonably, even if erroneously believed, no.
Okay, so basically
they're protected.
I see.
So even if he's wrong, as long as he believed, he could be a moron.
Mm-hmm.
That's a defense for them. Ignorance is a defense for them. It's not for you.
I see.
It's a defense for them, not for you. And by the way, I know I'm going off topic here, but this is another thing. When a police officer asks you questions, you have two options: either tell them the truth or shut up. That's it. Don't lie to the police. You can shut up or tell the truth, but you don't want to lie. Because if you lie and they find out, you can get charged with obstruction of justice, or worse, in certain instances, filing a fake police report. However, the police, when they question you, when they interrogate you, they can't lie to you to get information. You're perfectly legal.
Wow. But you just can't lie back.
Yeah, you just can't lie back.
Or else that's a false police report?
Well, you could be making a false police report, or you're obstructing justice.
I see.
You can't do that. You can't lie to the police. Your two options are tell the truth, shut up.
And just say, I'll plead the fifth.
Well, plead the fifth, you say you exercise your right to remain silent. Remember, you know the Miranda rights, you further the Miranda rights. You have the right to remain silent. Anything you say or do can and will be used against you in court. You have the right to an attorney. If you can't afford an attorney, the court will appoint one to you at public expense. Those are Miranda rights.
Now, what about things that you tell them before they can read your Miranda rights? Are those accessible in court?
Depends. Okay, here's the deal. See, the thing is, the police will almost always try to do everything possible to avoid. They will do their best to avoid having to read you the Miranda rights. Now, once they've arrested you, once you're under custodial interrogation, they have to read you your Miranda rights prior to asking you questions.
What is custodial
interrogation?
Yeah.
Custodial interrogation is when they've already taken you to the station. You already know you don't have the right to leave. That's been established. You don't have the right to leave. Now, a lot of cops, this is what they'll do to avoid having to Mirandize you. They will tell you, all right, sir, the door is open. You're not under arrest. You have the right to leave at any moment. They're checking the recorder to make sure that it can be heard. You have the right to leave at any moment. We just want to ask you some questions. They do that because if the person has the right to leave, they believe they have the right to leave. Well, then they don't have to Mirandize them. They don't have to say you have the right to remain silent. Da, 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 da. But once they tell them, you know what, you're under arrest. You don't have the right to leave. They have to Mirandize you to ask you questions. If they do not Mirandize you and they ask you questions, all of that anything you said is inadmissible in a court of law.
So then you could lie.
Well, yeah, but
It's not gonna.
it wouldn't really help you.
Yeah, gotcha. So if you are not, if you say to the police officer, may I leave right now, and they say no.
Oh yeah, then they have to Mirandize you.
They have to Mirandize you.
They have to Mirandize you to ask you the questions. Now here's the deal. There's a caveat to this. After they Mirandize you, you could say, no, I'm gonna keep my mouth shut. I don't want to talk.
Yeah.
The police can leave you in the room. They can come back an hour later, or 2 hours later. They can say, you know, have you changed your mind yet? They can do that. And a lot of times they can encourage people to change their mind. They can do that. However, if they exercise the right to an attorney under the 6th Amendment, then that's it. It's over. They cannot ask you any more questions. They cannot come back and bug you. It's done. So you want to always exercise your 5th and your 6th Amendment.
I see. So right when you're arrested, you say, right when you read your Miranda right, just say, I want to speak to my attorney.
And I'm not going to say anything. That's it. Done.
I see. And then you don't say anything until you're either put in that cell or until you get on the phone with your attorney.
You don't say anything. You just don't. You keep your mouth shut. Because it doesn't help. It never helps. It never helps. In my experience, and I've handled thousands of cases, literally, it never helps to speak to them. They've already made their minds up.
Yeah, exactly. Because then it's all into the courts, into the DA, and that's where you come in.
Exactly. That's where our office comes in.
All right. I don't know. I think that was pretty much my questions. I don't know if you have anything else to add. Or...
No, but definitely, like I said, anybody who is interested in our office answering your questions can keep listening to our podcast. And you can always give us a call at 1-800-530-1800.
Yeah, and then you can also visit the website as well at crosscriminallaw.com.
That's true, crosscriminallaw.com.
And they're always giving out free evaluations.
Absolutely, absolutely.
I look forward to hearing back from you guys next week or so. And until then, drive safe and be prepared. Know your rights.
All right, have a good day.